Hello and welcome. This video has been prepared by the City Bar Justice Centre's Cancer Advocacy Project and is part 2 of 2 informational videos that are intended to provide you with a simple overview of the main documents used for life planning, which is also called estate planning. This information is based on New York law and is not intended to substitute for legal advice. The main life planning documents are wills and advance directives, which allow you to name a person of your choice to speak or act on your behalf if in the future you become unable to handle your own affairs. In part 1, I explained the importance of having a will and provided information about what to consider when preparing one. In this video, part 2, I'll give a summary of the main types of documents that make up advance directives and which allow you to name someone to be your agent to handle various crucial matters for you, such as medical choices and financial issues, according to your wishes. Being able to maintain a sense of independence and control over your affairs is especially important when you have been diagnosed with a serious illness like cancer. And preparing in advance allows you to make key decisions regarding your wishes and who will represent you if you're not able to speak for yourself. So to begin, what are advance directives? When talking about advance directives, these are the names of the main documents that are generally used: Disposition of Remains, Healthcare Proxy, Living Will, Power of Attorney, and Standby Guardianship, which is an important document if your doctors believe that you may not be able to continue caring for your minor child or children in the near future. I'll explain the purpose of each of these documents shortly, but first, why are advance directives important? You can appoint someone, your agent, to act on your behalf for a variety of matters if needed. So depending on your wishes, some of the powers granted to your agents may include consulting with doctors about your medical treatment, dealing with your banking needs, negotiating with your landlord, or handling your burial arrangements. Now I'll briefly explain the purpose of each of the advance directives, starting with the healthcare proxy. The main purpose of a healthcare proxy is to enable a person that you choose, your agent, to make medical decisions on your behalf. So as an important point, your agent can only speak on your behalf if you cannot speak for yourself. So this could be a temporary situation, such as if you are unconscious or heavily sedated, when important medical decisions must be made, or maybe longer term, for example, when somebody is unconscious for a long time and may not recover. So in addition to your main agent, you can choose an alternate agent who can step in if your first agent is unable or unavailable to act for you when needed. You can only appoint one person, one agent, to act at a time. So you can't appoint 2 people as your primary agents. And very important, you must discuss your medical wishes with your agent or agents. Being somebody's healthcare proxy agent can be a lot of work, so you should certainly ask the person if they would be willing to act as your agent before you name them in the document. And if they agree, make sure to discuss your wishes with them so that they have an understanding of what you would like, what you would want, what your wishes would be in a variety of medical situations. The person that you ask to be your healthcare proxy agent may have concerns about what agreeing to serve in that role might mean for them, such as whether they would have to personally pay your medical bills if you could not pay. In fact, the law provides protections for agents. So, very importantly, they are not responsible for your medical bills unless they have an obligation for some other reason. So if they do not sign a document stating that they agree to take on your medical debt, they're not automatically liable. They're not liable for your medical bills. They're protected from civil and criminal liability for making healthcare decisions in good faith. And finally, they have no responsibilities, obligations, or authority after your death. The next document is the living will, which is also related to medical treatment and is not the same as a last will and testament or a living trust. A living will is a directive in which you can state what your medical wishes would be if you are in an end-of-life situation. It would come into effect if the doctors believe there is no possibility of recovery, and it allows you to tell your doctors in advance what to do in that situation. So, for example, your choice could be you do not want them to use invasive procedures or resuscitation attempts if you are in an end-of-life situation, or you can advise them that you would want them to keep providing medical treatment for as long as possible. You can also provide additional information about your wishes in an end-of-life situation, such as blood transfusions, hospice care, and pain relief. The next document is a power of attorney, which you can use to choose someone to act on your behalf for different matters. So the power of attorney allows you to name someone to handle your non-medical matters. A power of attorney is most often used for financial and property transactions. For example, banking or long-term care planning, or if you're querying medical and utility bills, housing-related issues such as speaking with your landlord, dealing with your taxes. And an important point to mention here is that signing a power of attorney agent, having someone agree to be your power of attorney agent, does not mean that your agent will automatically take over making decisions for you. You will still be the one making decisions about your property, and your agent must act according to your wishes. This only changes if you lose the capacity to make your own decisions, such as because of Alzheimer's or dementia. So keep in mind these additional points. At all times, if your agent knows your wishes, they must act according to those instructions. If you have not given instructions to your agent on a particular issue, they must act in your best interests. If you want to cancel, which is called revoke, if you want to revoke a power of attorney, you must do it in writing, and your signature should be notarized. You must send a notice to the power of attorney agent that the power of attorney has been revoked. And you should also notify any third party that has a copy of that power of attorney, so for example, your bank or broker or your landlord, so that they will be aware that it is no longer valid. Finally, a power of attorney does not last forever. It immediately expires when you pass away. So your power of attorney agent no longer has authority to act on your behalf at that point. It would be the person who is named as the executor in your will who would begin acting on your behalf, on behalf of your estate. The next document is the Disposition of Remains. This document is similar to a healthcare proxy, but instead of focusing on your medical treatment, it's your agent who is appointed to handle your funeral and or burial arrangements. So in the Disposition of Remains, you can state your wishes on those topics, such as your preference for cremation or burial, any funeral details, any preferred burial site, and so on. Preparing a Disposition of Remains reduces the chances of family disputes over who should take charge of making those arrangements. It also provides clarity for the funeral home. The Disposition of Remains document lets them know what the person's wishes were and who they had appointed to take care of those arrangements. And a few other points about the Disposition of Remains. It's also helpful if you do not have family members to handle your burial. You can purchase a prepaid burial plan and refer to it in the Disposition of Remains. and name a friend as your agent. This will enable your friend to work directly with the funeral home to follow your wishes. And by paying your burial cost in advance, your friend will not be responsible for those expenses, and they will also have authority to act on your behalf in carrying out your wishes. Unlike the previous documents, which become invalid upon your death, the Disposition of Remains document comes into effect at that time. The final document is the standby guardianship form, which is especially important if you are essentially a single parent of a minor child or children. In New York, the age of being a minor child is 18. So until a child reaches 18, they would be considered a minor. For the standby guardianship, you can use this designation as a parent with a serious illness who may become unable to care for their minor child because of incapacity or death. In that situation, you can designate a standby guardian by using a simple form. The goal is for the standby guardian to act as the temporary guardian of your child, but it does not remove your parental rights. So by planning in advance, there is less chance of your child being placed in foster care, and the arrangement will be less traumatic. A standby guardianship would go into effect only when you become unable to care for your child, which is called a triggering event. At that point, a doctor must confirm the existence of a debilitating or terminal illness which has progressed to where you can no longer care for your minor child. Importantly, you as the parent would continue to be involved in all the decisions involving your child. A standby guardianship is intended to be a short-term arrangement. If circumstances require that it needs to extend beyond 6 months, the standby guardian must apply to the court for full guardianship. The intention of this video has been to provide you with a simple overview of the key documents used in advanced planning and their purposes. Planning in advance gives you the most control over your affairs, as it increases the chances of your wishes being followed, which is critical consideration for people who have been affected by cancer. I hope this summary has been helpful in explaining why preparing advance directives is an important part of being prepared for whatever the future brings. You decide who should speak and act for you if you're unable to do so for yourself, whether temporarily or permanently. You can plan ahead so that the important people and matters in your life can continue to be taken care of with less disruption. An overview of wills can be viewed in part 1 of the Cancer Advocacy Project's life planning videos. Information about the Cancer Advocacy Project is provided on this slide and the following one. Thank you for watching.